Right, well, thank you all for coming along tonight, and welcome to the third in our series of Q&A sessions. Tonight's session is going to be focusing on family law. So we have a panel of barristers and solicitors that will be answering your questions in relation to this particular area of practice. I'm going to start by introducing all of our panelists. So first we have Jonathan Jackson, if you'd like to introduce yourself.
Yeah, sure. Good evening. I'm Jonathan Jackson. I'm a barrister at 18 St John Street Chambers in Manchester. I've practiced there since January 2017. I deal with all aspects of family law with a focus on public and private law children matters.
Thank you. We have Fazeela Ishmael.
Hi everyone, I'm Fazeela. I am very recently, I feel very strange to say that I'm a barrister. I just finished my pupillage, so I am 3 weeks into tenancy. Thanks, Antonia. So it still feels very strange to say that. I, similarly to Jonathan, I do all areas of family law and have mainly been doing public and private child so far.
Excellent, thank you. We have Antonia Birchall.
Hi everyone, my name's Antonia. I am a solicitor at Irwin Mitchell in Manchester. I qualified last year, meaning I've been doing my NQ year throughout the pandemic, which has been interesting to say the least. My practice involves finances, divorce, children, cohabitee disputes and everything else in between.
Excellent. We have Callum Brook.
Evening all, I'm a barrister at 18 State Central Chambers. I practice family law, I've been doing so since August 2017, mostly do public law with a little bit of private law chucked in.
Thank you. And lastly, we have Shabab Rizvi.
Hello everyone, I'm a barrister at Parklane, Plowden. I finished my pupillage in September and I've been a tenant for all of 1 month so far, and I do public and private family work.
Thank you. So that is our panel for tonight. In terms of the running order, the way it will work is we will start by running through some of the pre-prepared questions that you've sent through. So we'll spend the first 40 or 45 minutes working through those questions. During the evening, you will notice that there is a chat box. If you think of any questions, you can pop it in the chat, or when we get to the second half of the evening, if you're feeling brave, you can come on camera and ask the question. And I'm sure our panelists will be able to find an answer for you. During the evening, if you could keep your microphones on mute unless you're coming on camera to ask a question, I would be very grateful. So we'll jump straight in. And the first question, nice and simple. Why did you choose to practice family law? Jonathan, if you'd like to get us started with this one.
Sorry, John, I think my connection went a bit then. Did you ask me to answer that?
Sorry, yes. The first question, why did you choose to practice family law?
Okay, well, for me, and I think you may hear this from others, it wasn't really a conscious choice to choose to practice family law initially. When I was doing my studies, I knew that I wanted to come to the bar. I didn't study any family law modules or anything like that on either the LLB or the bar course, but knew that I wanted to get some practical experience after studying, applying for numerous jobs, and was offered a paralegal position in a family firm. And things have gone from there, really. I progressed from a paralegal to being in a fee earning position, and then did a predominantly family pupillage 4 years ago now. And I've practiced in family ever since. And so whilst I kind of fell into it, it's an area of law that I'm glad I fell into. I enjoy the work that's in that family law involves, types of cases you get to deal with. And I can't imagine practicing in any other area at the moment now that I've been doing it for this long. So it was a bit of a stumble into it, but I'm glad it happened.
Thank you. Fazeela, what were your reasons for going into family law?
So I feel like I've had to answer this question probably quite recently in pupillage interviews. But I think for me, it was the difference between family law and something like criminal or contract is that in criminal law, the harm's already been done. It's over. You're trying to work out who broke into the shop, who punched the woman, whatever, the harm is over. Whereas the difference is in family law, it's more forward focusing. You're trying to find problem solving solutions, or to try and make the child contact arrangements work in the future. And I think I liked that aspect of it, that it was about looking to the future and how those progress. And also because in family you're in court a lot of the week. You have it's a very busy practice, so I think that there's a good balance of being in court and also being in chambers as well.
Thank you. And lastly, Callum, anything to add at all?
Not really, mate, I'll be honest. That's my sage answer to that question.
Excellent.
I started with a mixed practice in crime and family, so I was straddling two camps, actually, as John well knows, having sparred with me once upon a time in Sefton Magistrates Court, and then saw the light, as it were, when my diary filled with family law work, and realised that I probably wasn't doing enough crime anymore to maintain a practice in it. So that is generally how I ended up doing family as a specialism, as opposed to still trying to keep a mixed practice going.
There we go. We have a variety of reasons there for doing family law. Callum's was probably so he doesn't have to come up against me in court anymore. On to the next question. Can you describe a general working week in the life of a family barrister or solicitor and the nature of the work involved? Antonia, would you like to get us started on this one?
Yeah, absolutely. I think the short answer to that, in terms of is there a general week for a family solicitor, is no, because I think everyone on the panel would agree that the work is just so varied, and literally, certainly from my perspective anyway, from one day to the next, I don't know what is going to come across my desk. So one day I could be thinking I've got a client, a quiet week this week, and then the next day something would come up, and then all of my plans for the week have just gone into disarray, and I'm having to deal with something else. So there isn't a general working week, in my opinion, but that's why I like it, because the work is so varied.
Brilliant. And Shabab, from a barrister's point of view, can you talk us through a general working week?
I think I'd have to agree with Antonia. I don't know if there is sort of a general way of how your week's going to go. A lot of the time we get cases quite last minute. You may have, like Antonia said, you might have a week that's looking a bit easier, and you may think, okay, well, I've only got a few cases this week, and then the night before you'll have a 2-day final hearing somewhere far in some far-flung place in the north of England. But that's definitely what keeps it interesting. I think it depends. I think if you've got several different cases over the week, they'll generally be smaller, more manageable cases that you sort of prep as you go along, provided you've got instructions and you've got your paper bundles and the like. Where you've got a final hearing, for example, that's over multiple days, I think that gives your day a little bit more structure in terms of when you're going to be in court and when you're going to be out. But there's no such thing, I think, as a typical or a general week.
Thank you. Okay, we'll jump on to the next question now. And it's, can you give examples of common cases that arise in family law? So, Jonathan, what is the bread and butter work in family law?
Well, for me, I do a lot. The most focus of my work is on public and private law children work. So you see a lot of care applications where local authorities are involved with trying to remove children from parents, or seeking orders to protect children. And then you have on the private side, applications made by parents for contact and issues to do with the arrangements for the children. So the typical cases that you'll see on a day-to-day basis are things like case management hearings in care matters to get the case listed for trial, directions hearings and things like that. And then you'll ultimately get the matter listed for final hearing. There are hearings called finding of fact hearings, which are particularly prominent in care and private law proceedings, where there are disputed applications that the court needs to deal with. And we come across those quite a lot, particularly as you get more experience. You tend to pick up the the trials and the hearings that involve more extensive evidence for the court to determine. So those are that's what I would say the bread and butter cases that you come across from a children perspective.
And as a newly qualified barrister, what kind of cases do you come across, Fazeela?
So mine are the kind of interim hearings. It might help to explain to everybody that, so when you make an application to the court, when the local authority is concerned about a child, the court just don't make the decision there and then. There are some set up hearings before this final decision, and that's what Jonathan was referring to, these case management hearings. So at these hearings, you are basically getting all the evidence together, all the assessments of the parents, the assessments of the whether they need to do a psychological assessment, whether there needs to be another family member that can be assessed as a carer. All of this evidence has to come in. And so that's been my bread and butter. I've been doing a lot of case management hearings. Today I had it was a directions hearing on the private child side of things. So that's, again, since COVID and lockdown, there have been quite a few cases where there are issues between contact between separated parents. So we've had a fair few cases come in for that, to regulate those arrangements. So those are the two types of cases I've been doing so far. I have got some money matters coming up, but again, those are just the beginning hearings. So I haven't done any final hearings myself yet.
Thank you. The next question we have is directed at Antonia. And the question is there much scope for solicitors to do advocacy in family law?
We briefly discussed this before everyone joined, didn't we? And my answer was yes, there is. Generally, if there is opportunity to do it, it's to do it at directions hearings, like the ones that Fazeela just spoke about. I personally would make a terrible barrister because I get really flustered and I'm not great on my feet. So when I have done a directions hearing myself at the very beginning of a case, I have hated every second. But to answer the question, yes, there is loads of opportunity to do it, and certainly my manager really actively pushes us to do our own advocacy, because it's good for the client. You know the case well, and it actually, in some cases, not all, saves the client some fees and keeps the costs down. So yeah, there is loads of opportunity.
Thank you. Okay, we'll jump on to the next question. And it says, what is the most difficult case that you've worked on, and what were the skills required for it? So we'll start with Shabab on this question.
I think the most difficult case that I've worked on is probably the one that I'm working on at the moment. It's one of those cases where you think that the clients are going to be difficult anyway, and then they are as difficult as you'd expect. A lot of this job is managing your clients' expectations. You know, whether you're representing a local authority and you've got your professional clients, you've got your social workers, or whether you're representing a parent who's about to have their child removed. And certainly you can have some situations where the relationships between all of these people has really broken down and it's quite acrimonious and no one gets along, and you are really trying to manage those relationships and just dealing with even small practical matters. So for example, organising pre-hearing discussions. So usually those are discussions that advocates will have prior to going into a court hearing, and usually lay parties aren't present for that. But there can be situations where, for example, you've gone into court and two parents have a very, very acrimonious relationship and actually can't be in the same room as one another, and you can't actually have a useful start to a hearing. So that's something that I've encountered quite recently, and it's really being proactive and looking to problem solve and trying to essentially manage the case and get things running in a very short period of time. So I think it's not just the legal side of things, it's being organised and being practical and making sure your case keeps running.
Brilliant, thank you. Do we have anybody else that would like to contribute on this answer in terms of any particularly difficult cases or skills required for difficult cases? No?
I would just echo what Shabab said, which basically my view really is that communication is really important when you're dealing with clients, and also I think it helps if you are naturally good with people as well, and you're able to influence them in a way that they might not be able to see right in that moment, but at the end of the case they will see it benefits their case, if that makes any sense. So people skills, communication skills, I think they're really important to be a decent family lawyer.
Okay, we'll jump on to the next question. What style of advocacy is most important at the family bar? Anybody like to jump in with a suggestion on this one?
Normal advocacy. I think the best way to look at family law is it's a mix of inquisitorial and adversarial. Some people will, obviously, we all have our own styles. And it really depends on what your background's like in terms of, have you done at different areas of law before you've started it, before you come into family law and things like that. You'll always spot the ex-criminal hack doing a bit of family law, because they will cross-examine witnesses as if they are in front of a jury, and it's all very closed down and it's very controlled questioning. Sometimes though, certainly if you like representing a local authority, you find that letting parents run away with themselves whilst they're talking, they're talking themselves out of being able to care for their children effectively during the course of cross-examination. So it's really about having an adaptable style. In some respects, you'll deal with some witnesses where, yes, a criminal style of cross-examination is probably mostly effective, because you don't want them to run away with answers. You want to keep the answers controlled and keep it concise. Others, if you know certainly if you've got a psychological report that says that they've got some form of personality disorder, which is going to really come out during the course of any evidence that they give, you'll let them run away with it. So I wouldn't say there's one particular style of advocacy. I think it's kind of like bringing a lot together in order to achieve what you're aiming for with a particular witness.
Interesting answer there, Callum. Does anybody else have any suggestions on this?
Perhaps if I just follow on from what Callum was saying, I think particularly when you're dealing with public law cases, you're often either acting for or acting against people who have some form of difficulty. Often there are mental health difficulties, because there's a reason why they're involved in the proceedings. It's not always the case, but more often than not, you're coming up against people who have got serious difficulties. So when you're cross-examining them, or you're making submissions in front of the judge and you're for the local authority, so you're against those people, whilst it is right sometimes that really you can give them a bit of rope and they'll hang themselves, like Callum says, but there's also an element of sensitivity, I think, because sometimes it's unnecessary to go hard on certain individuals where the case is so stacked against them, but you're dealing with really sensitive issues. For example, you may be dealing with a final hearing where somebody with significant mental health difficulties and other difficulties is facing the prospect of their child being adopted outside of the family without their consent. Understandably, you can give them all the advice about the prospects of them successfully defending that, but because of what they're being faced with, they often want to run the final hearings, even if it's a completely hopeless case. So there is an element of needing to adapt to the people who you're having to ask questions of or make submissions about, and be sensitive with it. So I think sensitivity is a key quality of family bar.
Thank you, Jonathan. Right, we'll ask the next question now. And the question is this: what sort of work experience would boost a pupillage or training contract application? Does anybody have any suggestions on this question? Well, I suppose I'll expand it further, not just work experience, anything that can help. What would you say can help a training contract or pupillage application?
I think it's important not to limit yourself. Mini pupillages are quite hard to get, I think, especially now, given the current situation. I know some places are offering sort of virtual mini pupillages, and if you're able to get them, that's great. But something that I found helped me was having a varied experience. So I did a number of different things before I came to the bar, and indeed before I started pupillage. I worked in various places, and I was able to sort of pull together the different things that I'd learned from that. And I mean, given any sort of customer facing role, anything where you've had to deal with people or be around people or handle people is always really helpful. I used to do some admin work at a medical practice, and I'd have to deal with patients sometimes. And I don't know if you've ever been at a busy medical practice on a Monday morning with a queue of about 50 people, but it really does put you through your paces. But if you can sort of demonstrate what you've learned from that and how it applies to a life at the bar, I think you'll do well.
I think just to add to that as well, one thing that helped me was to write, I made a table of all the skills that a barrister could possibly need. It's not just legal research and advocacy, it's the determination, the perseverance, the diligence to get up, to leave your house at 5 o'clock in the morning to go and get a train somewhere. All of these other skills that you've got to demonstrate being a barrister, managing your own practice. So building on what Shabab said as well about the client handling, I was a tennis coach for a couple of years, and I used that because you have to speak to different people on different levels, and that's really important as well. You're speaking to a client on one level, speaking to your colleagues on another level, and then to the judge perhaps on another level as well. So I think it's not just thinking of the standard experience people will have of mini pupilages and paralegal roles, but going beyond that. What else can you do, whether it's door-to-door sales or whether it's just working in a restaurant? All of those things, you're managing lots of different tasks and choosing which to prioritize, and you can build all of those into your applications.
Yeah, very good advice there. I think that's the thing for any sort of application. If you're going in to be a lawyer, whether it's a solicitor or a barrister, it's how you use those transferable skills. So just general skills that you've gained through life, how can you transfer that to A, being a lawyer, and B, the particular practice area that you're interested in?
I really hated talking on the phone, so I made myself go and volunteer at Citizens Advice where I was answering the phone, purely because I could develop that skill, because I think you're right, you need to develop it.
Yeah, absolutely. Right, do we have any other suggestions in terms of things that can help with training contract or pupillage applications? No? Okay, well, with that, we'll jump on to the next question. Nice, easy one, actually. What is your favourite aspect of working within family law? We have 5 family practitioners. Hopefully, one of you enjoys some part of the job.
Mine would have to be winning. So I had a final hearing on a private children case yesterday, and there were really narrow issues because fortunately the parties had been able to get along a bit more during the course of the proceedings, but that meant for my client that it was quite risky in terms of which way it was going to go. The judge was either going to be with us or she wasn't. Unfortunately, she was with us, and the client, I acted for Dad, was so grateful, and he was crying over Zoom to me, which was slightly awkward, but also very nice and rewarding. So that's one of my favourite parts about the job, I think. Winning.
Brilliant. I suppose that's why all people go into law. Yeah, any other suggestions at all?
Well, I suppose it's part of it's also knowing that you've probably made some kind of difference to somebody's life in effect. Even, but if you act for parents in care cases, look, putting it particularly bluntly here, you're climbing mountains at the end of the day, trying to argue against the local authority, and certainly children's guardians at the moment. And realistically, even if the one impact you've had is to make them feel more comfortable about what they're going through, and allowing that kind of split between them and the process and helping them through the process as well. And that in itself can be quite rewarding, because ultimately the ending is never going to be pleasant for these people, realistically, unless they've done absolutely everything, dotted every I, crossed every T. So really, it sometimes boils down to that little bit of almost social work impact that you have on some parents and circumstances.
Thanks, Callum. Anybody else, anything that you particularly enjoy about the job, or have we covered most things, would you say?
I think one of it is advocacy. I think if you're definitely, if you are a barrister, if that's what you want to do, then you have to enjoy advocacy. And for me, that's always been something I've enjoyed. And it can be daunting at times, and I think especially at the start, it can be a little bit worrying or a little bit scary. But once you've, actually had the chance to put into practice this cross-examination that you've spent hours and hours drafting, and you actually see it going well, that's always quite a good feeling, I think.
Excellent, thank you. Right, we'll jump on to the next question now. Given the family law is not taught on the GDL, what would the panel suggest are the best ways for prospective pupillage applicants to gain an understanding of this practice area? So for GDL students,
mini pupillage is probably the best bet here. Appreciate anyone who does the GDL, they appreciate that they're just doing the six qualifying modules that they have to get in order to be able to practice law effectively. So yes, I get that there's little scope, but also when you do your BPTC or PPC as it's called now, or you do your LPC or these solicitor super exams, whatever it is that they've brought in as a means of qualifying as a solicitor now, that most providers will offer a module of some sort that does deal with family law. If it's an area you're interested in, I appreciate some people may feel like they don't want to pigeonhole themselves into that much of a niche speciality, maybe take a bit of a broader approach. But mini pupillages or going into firms doing work experience is probably your best bet there in order to help you understand what it is that is expected of you, what the job looks like, what we're required to do. And oddly, you will find that for the most part, we spend a lot of time sitting around waiting. That is one main part of the job.
I think that's true for all practice areas. Most of the job is sat just waiting in common room areas in court. Right. Does anybody else have any suggestions on this answer?
As well, maybe given that it's so hard to get mini pupillages, maybe you could try and tackle the issue or get an insight into the issue from another perspective. So in terms of domestic violence or non-molestation applications, you could volunteer with the domestic violence helpline, or Gingerbread is the charity for separated parents. That's another way to get involved in those issues. Maybe PSU, the witness support, something like that, all of these other issues that surround family law. There's also FRU, which is the Free Representation Unit. You can represent appellants who are challenging their benefit appeals at tribunals. So whilst benefits aren't directly related to family law, a lot of in care work, a lot of your clients are going to be on benefits. So if you've got a case, if you've got an understanding of benefits, that also helps. So I think I would try and think about how you can get an insight into those issues from a non-legal perspective, and that might help as well.
Very good answer there. Right, I think we'll jump on to oh, sorry, do we have another?
John, I agree with all the things that have been said, but all of those are going to give good experience of practical things. And if it's just an understanding and knowledge of the law, then a simple thing to do is have a look at the Family Law Week website, which has all the significant judgments. It's updated regularly. There are articles about various topics on family law. That's a good way. That's the way I use to keep up to date with developments and what's going on. So if you want to develop a basic understanding, then have a look at that.
Thank you. Really practical advice there. Okay, we'll jump on to a few more questions before we jump on to the questions that you've popped in the chat. Next one, is the work-life balance good when practicing family law? So does anybody want to comment on your work-life balance?
I don't think the work-life balance is good in the job, full stop, John, to be perfect. Work-life balance is what you yourself want it to be, ultimately. If you want to work every day and be in 5-day trials, then that's your prerogative. Certainly as being a self-employed barrister, that's your choice. There was a member of my chambers who for years just didn't do any final hearings because she felt she didn't have to, she didn't want to, and that suited her practice model. So yes, some of us will be up until 3 o'clock in the morning reading pages and pages. I think I just finished one case where the bundle was 3,800 pages long. You know, ultimately it's about your own well-being and how you manage your own well-being. And it is the buzzword at the moment, and it is going around, and we keep getting emails from the FLBA telling us how we need to manage our own mental well-being and how COVID's not really helped the situation. But at the end of the day, the job's not changed for nearly 1,000 years, really. So fortunately, it's down to the individual to manage their own work-life balance.
There we go. Right, any other suggestions on this one? Or do we agree with Callum?
Experience as well, but I think because of COVID, you aren't, and we're doing all these remote hearings, you don't, whereas before you would do one case a day, you travel to that court and you'd go and do that one case. What happens now is that you have a case in the morning, and sometimes you'll have a case in the afternoon as well in a different court, but because they're both remote, you can do that. So it means that and there's no real separation either. So you kind of have to make that, as Callum was saying, you have to create that separation yourself. You have to put your laptop away, close your books, put them away somewhere. Otherwise, you don't stop thinking about work. And I think it's become a lot harder to manage your practice in COVID because there is really no separation now. The majority of the work are all these remote hearings, and so it means that you sometimes do two hearings in a day, 1 to 3 hearings in a day as well. So I think you have to be really on it, and you have to take steps to manage that.
Excellent, great advice there. Right, last one before we jump on to any questions from the audience. What qualities do chambers and law firms look for in applicants?
Is that generally or in
relation to family law? But the question's no more specific than that, so take it as you will, Callum.
From my perspective, I generally look at if say, for example, when we're doing pupillage interviews, one of the central things is, you know, are we going to get on with this person? Are we going to be able to work with this person in the long term? Are they going to fit in? Because of course, different chambers develop different personalities. You unconsciously seem to you end up recruiting like-minded people that when you're in the middle of an interview and it's almost you're going through the process of well, this person would fit in really well, or maybe that person might be a better fit for a different set of chambers that have a bit more of a different dynamic in respect of depending on specific practice areas. What I'd say is, obviously, if you're really, really interested in family law, and I know there is this massive scattering approach when you do pupillage applications to get as many applications to as many different chambers as you possibly can. If you're really interested in family law, obviously apply to sets that have a large presence in family law. We had, interviewed one guy. He was absolutely fantastic candidate, but he just kept talking about immigration law, and we're sat there going, come on, let's talk about the topic here that we really want to talk about, which is family law, because that's what we're recruiting for. So, if there's a particular quality that you look for, sometimes it does boil down to as simply as, are we all going to get on with each other in the next 10 years, or are we all falling out? Is it going to work as a working relationship between those? Because the difficulty with chambers is it's like a really dysfunctional family of people, or that we conveniently all work together. But by God, if you ever sit through a chambers AGM, you soon find out who the hated uncle is in the corner and who's who's causing the AGM to run on for about 3 hours when it really shouldn't be doing. So, but at the end of it, you've got to be able to all take a step back and go, but we all still like each other. That's the main problem. So be yourself, be personable. Obviously, academics are very important, etc., in terms of your work experience as well. And look at chambers in the sense of why specifically do I feel like I would fit in with this chambers? Because you may apply to some chambers, you may go to the interview, you may think, oh my God, who are these people? I'm never really going to fit in with these people. You may go to another chamber, you may go, oh, I really like this lot, and that kind of attitude. So have a look at people's profiles, see what they're saying about themselves. Some chambers don't put anything about them, the personal stuff anymore on their profile. Some people put what hobbies they're into and things like that. So have a look at that, see if there's any clues on there as well about, am I going to be able to make a little hole for myself here? Is this going to become a professional home that I can live with? And then equally, we've got to decide if we like you as well. So that would be my advice in respect of that.
Some good tips there, Callum. I think we've all learned quite a lot there. Anybody else like to comment on what law firms or chambers are looking for in applicants?
I would agree with what Callum said. And when I was training, one of my supervisors said to me that a test that they use is whether they can leave an applicant in a room with a client and they'd be okay. And I think the point behind that was really, theoretically, of course, they wouldn't just leave you in a room with a client on your assessment centre or whatever. But I think the point behind that is trying to establish through the interview whether that person has the people skills to be able to deal with someone, because I think often in law, you will come across a lot of people who are technically fantastic and really good, but in family law, I think it requires that innate ability to connect with people, I suppose, and connect with the clients and really push their case. And ultimately, if you don't have the people skills to be able to do that, then maybe family law isn't the right area. There are other areas where you don't require those people skills, like real estate or corporate or something transactional.
Thank you. Yeah, anybody else want to comment at all on this question?
I think one thing that's been helpful to me, at least, is being approachable. You're going to meet a variety of different people. You'll meet people from chambers, you're going to meet other barristers that you're going to work with, you're going to meet judges, clients and the like. And I think approachability really does help. It includes body language as well. So if you look like you're really closed off and your shoulders are hunched and your arms are crossed, then you're less approachable and people might want to speak to you a little bit less. And certainly being approachable to people around you, for example, judges, clerks and the like, that's really helpful, especially in your professional career, because clerks can get you a really long way. They can really help you. So just being sort of nice and polite and making an effort to speak to people and get along with people does help.
Absolutely key advice there. You're not going to get anywhere by treating people the wrong way in this profession, so it's all about being open and professional with as many people as you possibly can. You quite often have it where you'll come up against opponents and they're a little bit standoffish. It doesn't work at all. This is not me speaking about family law, this is the law generally, but yeah, such great advice there. Right, I think what we'll do now is we will turn to the questions that you've been putting in the chat. So if you think of any more, keep popping them in and we will work through them. So the first question I can see is, will changes to divorce slow business and have legal aid cuts affected the volume of work? I don't know if anyone wants to jump in with a suggestion on this one. Looks like that might be a two-part question, actually. So first thing, will changes to divorce slow business? Anyone?
I assume that, oh, Jonathan, do you want to take this?
I think I was about to ask the same question that you were. An assumption that what's being asked about is the bill that's going through at the moment about essentially adding altering the grounds for divorce so that it removes the blame game. I presume that's what's being asked about. I'm not aware of any other significant changes that are due to come in, unless I've missed something.
We'll work on that piece.
From my point of view, I mean, I'm probably not the best person to answer this because I tend to not deal with things like divorce petitions. That is the remit of a solicitor. So it might be best if Antonia, you were going to answer if I hand over to you.
Yeah, from my perspective, I don't think that it will slow divorce down or mean that we get less cases as a result, because I think it's a really positive step, and I come across a lot of clients who are really quite amicable, with their soon-to-be ex-spouse. So I think the no-fault divorce bill is really positive, and I don't think it will have an impact on divorce rates at all, she says, but I will need to research that after.
All right, and the second part of the question was, have legal aid cuts affected the volume of work?
No.
No.
No is the answer to that question. Look, in terms of public law, Children Act proceedings, you get legal aid, and that's just the way it works. In private law, you don't get legal aid, or your means assessed, or unless DV has been alleged, or you get exceptional funding. But ultimately, it's not reduced the number of applications running through the court. And it's yes, on occasion, certainly in private law stuff, you see more litigants in person, more occurrences of Mackenzie friends, which are the absolute bane of my life sometimes. But ultimately, in what, for example, me and Jonathan do as our primary area of practice, know that in fact, we've probably seen, certainly in Manchester, there's been I think it's been a 33% increase in the amount of care proceedings that have been issued by the local authorities in the area. So it's just, and now we're just waiting for, obviously, kids went back to school. Schools are an indicator of when things are wrong in terms of people's families and that. We're just waiting for the inevitable nuclear explosion of things that we've all missed or has been missed due to COVID. So no, in fact, there's probably more work than what we can all handle, realistically.
Yeah, I agree with that completely. Certainly from a care perspective, there is more work than can be handled, for definite. From a private law perspective, I agree with Callum that I don't, from my point of view, from what I've seen, I don't think the volume has changed, but the way in which cases are being dealt with is different because of the legal aid cuts. As Callum says, there are most cases now in private law where you have people who are on low incomes but won't get legal aid because of the cuts. They're either doing it themselves, so you come up against litigants in person, or they have the dreaded Mackenzie friend, which causes its own difficulties at times. So it's not the volume, it's the way it's being dealt with.
Brilliant. Thank you for the answers there. Right, next question. What are some key developments in family law we should be keeping an eye on? Any key developments coming up that students should be aware of?
There's nothing particularly about care that's coming up. We have the government backdoor in the statutory went through for the purposes of coronavirus about local authorities not having to go through jumping through certain hoops in certain adoption cases, but that passed out on the 25th of September, so it automatically went. The main thrust at the moment seems that in terms of the cases coming out of the Court of Appeal seems to have all centred around proportionality and defining proportionality as a concept. But ultimately, there's nothing, certainly nothing I'm aware of. Jonathan might correct me if I'm wrong, but there's nothing I'm aware of that's coming through the system at the moment that's going to be ground-shatteringly changing things.
Not aware of anything major. A lot of the things that have been going through the Court of Appeal lately and the Supreme Court, I think last year, were to do with applications involving deprivation of liberty. That's an area that's always developing. I think that's an area that people are interested in practicing. It's kind of an offshoot of family law, because you tend to get some people that deal with both the care side and the court of protection, high court jurisdiction of dolls. So if that is an area that you want to practice in, it's useful to keep an eye on things that are developing there, because that's always developing.
We have a question here. The question is phrased, is there much advocacy involved when working as a family barrister? Obviously, we've talked extensively about the advocacy that's involved. I suppose one way to ask this would be, do you find you have paperwork days as well, or is it sort of 5 days a week in court?
No, it's a court-based practice.
Yeah,
absolutely a court-based practice.
I can't remember the last time I had a day out of court purely to deal with paperwork. I often ask for days out of court so that I can physically catch up on things like attendance notes, but I don't get briefed to deal with advices or things like that. It isn't a written practice, it's purely advocacy, I find, court advocacy.
Okay. All right. Question here. Do you deal with one matter at a time, or how do you do this? What about the day-based solicitor? So, I mean, once again, this has been touched on briefly. When you're not trialing, do you find that you have more than one case in a day?
Yeah, it happens.
I'm seeing nods.
Yeah, it happens. I mean, if you ever take a trip to Liverpool Family Court, you'll find that certain practitioners have 5 cases in one day because that's just the way they blocked on contracts with the local authority. How they do it, representing the local authority in 5 separate cases, I have no idea.
All before different judges as well, often.
Yeah, but there seems to be this unspoken kind of rule between the clerks and these barristers that they'll just get away with it. And then I'm sat there with my one case until 4 o'clock in the afternoon, wondering what the hell's going on. Why am I still in Liverpool? But there we are. Some days, yeah, as Fazeela said, some days you'll have 2 cases in. We're fortunate in terms of Manchester because it is a very large court centre. So we're rarely cross-courted in terms of having to be in different court buildings. We'll have multiple cases in the same court building. But most of the time you would really just be doing IRHs and CMHs in respect to case management hearings or issues resolution hearings if you had more than one. Dreaded cross-courted in terms of final hearings. God, put your tin hat on because God help you. Frankly, if you're cross-courted and you've got a final hearing going on.
One thing I'd say as well is even if you haven't got a hearing on that case, you might have like an advocates meeting. So an advocates meeting is where the lawyers meet a day or 2 before the hearing to see whether anything can be agreed. So you might have a hearing on the day, and then in the afternoon you have this advocates meeting. So even though you're not in court on that matter, you probably have to have your mind in 2-3 cases a day, just so you've got them ticking over. And you might be in court doing one hearing and then have an advocates meeting on another case, and then when you come home drafting the position statement for your hearing the next day. So you've got to have a hand in the different cases.
Thank you. Great tips there. Right, next question. How do you deal with family members where tensions are high and there are disagreements? So I think this is something that Shabab was talking about earlier. Any particular skills involved to manage people in this situation?
I think it depends on who you're representing. So I think if you're a local authority, it's a little bit easier because you've not got your client kicking off. Where you're a parent, I think you would try to take steps to have them in separate rooms. So one of the things that we're doing at the moment is keeping parents who don't get along in different rooms and making sure that they use different entrances when they come in, or having staggered entrance timing. So somebody turns up, 20 minutes earlier than another person, effectively trying to make sure that they don't come face to face. That's really, I think, a team effort. Everybody sort of works together to make sure that that's organised and that's done, and everybody can try and give their evidence in a safe and secure way. So really, you have to try and be patient and try and organise it. And yeah, that's the best I can give.
Okay, thank you. Flip question from what we had earlier. So we asked what you like most about family law. What do you like least about family law? It's a tough question, so if nobody can answer, I understand. But if anyone's got a suggestion, feel free to jump in.
I don't mind sharing that. One of the things I least like about family law is arguing over a bill with a client. Obviously, because I'm a solicitor and we bill at the end of the case every month. Often, well, not often, but every now and again, there can be a client who is paying from the monthly income, and it's expensive to instruct a solicitor and a barrister, and you're in proceedings and you've got multiple hearings. And from the perspective of a solicitor, I find it really draining when you have to deal with that element of the job, because there are so many other things that I enjoy doing, and that kind of takes the fun out of it, talking about fees for me. But it's a necessary part, but not fun.
Yeah, it must be difficult, that. Yeah, it's going to be hard. Right, it looks like we've got another question specifically for you, Antonia. If you want to be a family solicitor, do you recommend training at a family law firm, or do you think it's more beneficial to train with a full service firm, gain experience of different seats and move across?
Well, I trained at Irwin Mitchell, and they are a full service firm, and I did my training contract was predominantly PI with a seat in family, and doing family now. I find that my experience from PI and dealing with the CPR and all of that stuff has come in use in certain areas of family work. I also find that it's really helpful having trained in a full service firm, because there could be a tax issue come up on a finance case, and we have a tax team, and 9 times out of 10 I'll know someone in there and I'll be like, hi, can you help me with this, or a property issue and stuff like that. So that's one of the benefits of training at a full service firm. Equally, I think there are loads of really good boutique firms in Manchester now, where they offer great training and they deal specifically with high net worth cases and stuff like that, and their training contracts are equally as good, and I'm sure they are able to get around those issues that I would just ring someone up in a different team.
Thank you. Hopefully that's answered the question. Next question we have is not specifically on family law. It's one for the barristers. In terms of pupillage applications, are you generally quite concise with your answers, or are you more verbose? Does anyone want to jump in on this one?
Depends on the interview setup, I imagine. I can only speak for the way my chambers deals with it, but some chambers will do two interviews. So you'll have a first interview, second interview. In terms of the first interview, ours are certainly, they're set questions. Everyone gets asked the same questions, and you get 10 minutes with us. And then we'll go on to the second interview, which is the more free-flowing interview. And ultimately, we want to know what you like as a human being. So if you just give us one-word answers, we're never going to know always. So I think you'll get the clue from the questions you're being asked, really, as to how much detail and depth that you potentially need to go into in terms of any pupillage application or pupillage interview that you're going through.
Another question.
In terms of, oh, sorry.
No, carry on. No, please go ahead.
In terms of the actual application form, so on the pupillage gateway system, you get asked, there are about 4 or 5 set questions. Those questions are usually things like, why do you want to be a barrister? Why family law? Why this chambers? Those sorts of things. The best advice that a barrister gave me when I was going through this was, think about the person who's reading that application. They're going to be a barrister themselves with a busy practice. They don't want to be sifting through all this long, complicated language, which doesn't really get to the point about anything, right? So you need to make sure that what you're saying is clear, concise, well structured. Don't go off on one about something that's not very relevant. What I think helps is if you make the points you want to say, leave it for a few days, come back and read your answer again, and make sure that you are clearly highlighting the subject of that answer in the first sentence or so, because you're making it really easy for the reader who's looking at your application form. I think if you need to make it clear. I think that's probably the best thing. In terms of the interview side of things, you can follow a similar style. So they use the STAR structure, which is situation, task, action, result, where you can use that in your answer. But as Callum said, don't be a robot about it. Just answer the question in a natural way, right? It's not about, you're not trying to find the perfect answer. You're trying to show why you're a good fit into the chambers and why the chambers are a good fit for you. So don't think you have to be this robot or come up with this one perfect answer, because there isn't one.
Thank you. Good advice there. I think one thing I would say from doing lots of application forms, and whether you're applying for a training contract or a pupillage, is avoid unnecessary words. So quite often you'll see things like, my answer to this question is as follows, or the furthermores, henceforth, whatever it might be at the start of the sentence. Just get to the point. It keeps it short, and as you say, people are busy or reading application forms. They haven't got time waffling through. They want it to jump out off the page while you're the person that should be interviewed. So keep it brief, or as brief as possible, and avoid anything that really shouldn't be in there. Keep the waffle out. Another question that tags onto that I've seen in the chat is, what do you think landed you the pupillage? I don't know if anyone's got any suggestions on that you think, or if not landing you the pupillage, at least got you through the door for the interview.
I think for me, it was making the panel laugh. And I know that sounds perhaps an unusual way of doing things, but when it came to the set of interviews that landed me the pupillage, I decided that I was going to try and be myself. It's a very difficult thing to do. I think you come in with this idea of how you think you should present yourself or what you think the Chambers wants. But I mean, it's very good to be aware of what you think a Chambers is going to want from you, sort of in terms of commitment to that local area or things like that. But really just be yourself. If you're, you know, a person who's naturally witty or funny, let that come through. Again, don't be a robot. Obviously make sure that any jokes you do make are appropriate or anything of the like, but so I think I've spoken about this before as well, but one of the things that helped me in my interviews was when somebody asked me what my hobbies were, I actually talked about them. So it wasn't sort of the generic things that people say, well, I like to read or I like to do this. I talked about the hobbies that I had and how I was really bad at them. And why I was bad at them, and that really made the panel laugh, and it turned into sort of what was likely to be a 2-minute question into a 10-minute conversation, and that really gave me an opportunity to sort of show them my personality and what I was like, and perhaps give them more a reason to feel like I would fit in with that Chambers. So really do be yourself, and don't be afraid to show your personality within reason.
Thank you. Any other suggestions in terms of what you think helped you get over the line? No? Well, I think that was really good advice there, because as we've said, at the end of the day, you know, whether it's a law firm, whether it's a Chambers, they don't want a robot, they want somebody interesting. And I think that if you're asked a question about your personal hobbies, if you can actually go and talk about them, it shows that you're more than just a law robot that reads textbooks and takes exams, and it shows that you're somebody that they can get on with. So I think that's absolutely key. Got a question here about training contracts, but I'll expand it to the barristers as well. At the end of your training contract or pupillage, if you're in Chambers, what's the prospect of an NQ role or tenancy at the end of a family training?
From a pupillage perspective, it very much depends on the that you're undertaking pupillage at, I would say. For my set, we only take on pupils if there is space for a tenant at the end of the pupillage, and we recruit pupils on the basis that they will successfully go through pupillage, complete it without any issues. In their second SIC, build up a good practice, develop good relationships with solicitors that will then continue into tenancy. I know that there are other Chambers that operate a slightly different way, and they take on sometimes 3 or 4 pupils where there may only be 1 or 2 slots for a tenant at the end. So there is an element of competition between the pupils, but it very much depends on the set that you get pupillage with, from my experience.
Just going on from Jonathan's point, so when I did pupillage with my co-pupil, we were told right from the beginning that we've taken you both on the understanding that you are going to progress and improve, so that there are 2 tenancy spots available. So we were made to feel right from the beginning that we were co-pupils as opposed to in competition with each other. So I think that really helped, because pupillage is an experience like no other, and if you have somebody who uniquely understands that experience as your co-pupil, that really helps. So at Harcourt Chambers, one thing they said on their application form which stood out to me when I was applying was that on their website they'd written, "We are not a pupillage factory," and I referenced that in the interview because to me that was really important. It's not about churning out these pupils and taking one of them on. It's a dedicated interest in your progress and how you'll progress as a barrister. And so Jonathan's right, it depends on the Chambers themselves, but I think we're moving more towards Chambers who would recruit with tenancy spots. But it depends on the chambers. You would need to look into that chamber specifically, look at how many pupils they've taken on in recent years, and how many tenants they've taken on in recent years, and how many pupils they took on. It also, in terms of the actual process of going over, so again, every chambers is different. So my chambers, the way they did it is you start taking on cases in your second sixth. So that means you are with different solicitors before different judges. So they compile a report on you. There's a tenancy committee, and so they obtain feedback from solicitors, judges, the clerks, other members in chambers, and the tenancy committee. They prepare a report. I would love to know what is in that report, but you never find out. So they write this report, and then it gets sent around chambers, and everybody has to decide. So there's a voting system in chambers, and with us, as long as 75% of the members in chambers voted that you would be join chambers, then you're off the tenancy. But again, every chambers works differently. You'd have to speak to these particular ones.
Thank you. Good advice. I hope that was a helpful answer there. Do we have any other suggestions on this particular question?
I would agree with what everyone has said in terms of generally at a law firm, if you are offered a training contract, certainly at Irwin Mitchell, it's because they've got a job for you at the end of it. That being said, it does depend on what the market is like at the time, which area you want to qualify into. I was really fortunate because on my trainee intake, there was another lady who also wanted to qualify into family, and they took us both on at the end. So I think it just really depends on the firm and the area that you want to qualify into in terms of whether you're able to get an NQ job.
Excellent. Some very hopeful words there from all of our panelists. So things are looking bright if you do land your position as a trainee or a pupil. Right, I think we're coming up towards the end now. So what I'm going to do is I'm going to turn to all of our panelists one by one, just for some final words, little soundbite, so to speak, or final piece of advice from each particular panelist to leave you with. So I'm going to turn to Jonathan first. If you'd like to leave us with some words of wisdom.
Well, just really to say good luck to everybody who's in the process of in their studies and hunting for pupillage and training contract. The best piece of advice I think I could suggest is try your hardest to try and get some practical experience of any area of law that you want to practice in, whether it's family or something else. Practical experience is one of the key things that chambers and solicitors look for, as well as having all the personal skills that we've talked about. So try and get some of that, whether it's through a mini pupillage, which I know are difficult to get at the moment, given all the problems that are going on, or a paralegal position or something like that. Anything like that will help your application. And I would suggest that you even if it's not a full-time position, it's just the occasional work, then that will stand you in good stead, I would suggest.
Thank you. Fazeela, any final words?
I think I probably have two main tips. Be authentic and be resilient. So I think one thing we probably haven't mentioned today is the road to a training contract and the road to pupillage is difficult. And I think we need to acknowledge that it's not something that everybody succeeds at. And it's not something that you can just decide on the day, this is what you want to do. It's about this dedicated decision that you've made, backed up by the experience that you've gained, and backed up by a sincere interest and genuine interest in the area. One thing that I think is particularly important is don't be put off by the solicitors and barristers that you see. If you feel like you are not reflected in the people that you see, don't let that put you off, because you have something to bring as a barrister, regardless of your background, regardless of your ethnicity, regardless of your opportunities that you had in life. You have something to bring. And if you genuinely believe that you have something to bring the profession, you have a genuine interest, work on that, use that, because that I think makes a difference. And I think particularly when I was going through this process, I didn't see many Asian female barristers at all, but I didn't let that stop me from becoming the barrister that joining the profession that I wanted to. You have to have that belief, and that's why I say be authentic. Don't be the barrister you see on TV, be the barrister that you see yourself being. And on the resilience point, don't be put off by it either. We acknowledge it's a really difficult thing to do, but you've got to take steps. Be prepared for the rejections, be prepared for the knockdowns, and work out, right, this was the no. What do I do to get to the yes? It's a marathon, not a sprint, somebody said to me.
Thank
and
you.
Good luck with it all.
Yeah, very inspirational words there. Antonia, anything to leave us with?
That's a very tough act to follow, because absolutely everything that Fazeela said I would completely agree with. I think it's about being authentic, showing your personality, particularly in your applications, and being yourself, and don't be afraid of rejection. We've all been through it. I applied for about 6 or 7 training contracts before I finally got a yes. So just keep going, that's all I would say.
Brilliant. Shabab, any final words?
I think I echo what Antonia and Fazeela have said. If I could just stress, failure is, I think, a natural part of this. Very, very few people get to where they want to be in this profession without having failed or without having gotten things when they wanted to. So if you're not getting the interviews, or if perhaps you are doing the interviews and you're not getting to where you want to be, don't be disheartened. Do take care of your mental health. Like we've said, well-being is sort of the buzzword, but it is quite important. You need to take care of yourself. One of the things that helped me was actually reflecting on the reasons why I wasn't getting to where I wanted to be. So if that's a lack of practical experience, then look to see what you can do and come back as a stronger candidate next time. But yeah, that would be sort of my few parting words.
Brilliant. And Callum, would you like to finish us off tonight?
Oh, my friend and learned friends have made all the salient points for me. It's pretty much like being in the Guardian brief, as I've got nothing else to add. But yeah, everything that's been said, resilience, sticking at it, you'll get you may not get where you want to be at the end of this process, but the process itself will be character building. And I can't promise that you'll all get pupils. I can't promise that you'll all get training contracts. But there's a certain character in trying and sticking at it. And inevitably, I wish you all the best of luck. That some of you, not all of you, will become barristers or solicitors or whatever it is you choose to do with your lives. It is an incredibly rewarding profession to be part of. It's also incredibly frustrating. And actually, what was being said about failure, if you can't deal with failure, I mean, 50% of your professional life is going to be failure, because you're not going to win everything. So you need to have a particular constitution for it. But I'd say keep your head high and keep going at it, because eventually, hopefully, you'll get to where you want to be.
Brilliant. Great advice from all of our panelists there. I think what we can see, you learn a lot more through your losses than you do through your wins. Well, I'd like to thank everybody for coming along tonight. Thank you particularly to the panelists. Thank you for your questions, and I hope it's been an enjoyable evening for you. We do have one more Q&A session, same time next week, 7 o'clock on Wednesday. The final session is going to be on personal injury and clinical negligence. If you've not signed up for it and you want to, go onto the website speedmooting.com and you can sign up for that event. I'd like to say a final thank you to everyone, and we'll see you again next time. Thank you.